Welcome to Thinking Like a Lawyer with your hosts Ellie Mistal and Joe Patrice, talking about legal news and pop culture, all while thinking like a lawyer. Here on Legal Talk Network.
Oh, hello. Didn't see you there. This is another edition of the Thinking Like a Lawyer podcast. I don't know. I felt like shaking things up.
I like it.
I've done the same intro every time for several years now. So I'm Joe Patrice from Above the Law, which you probably knew if you were listening to this. So I am joined by one of my fellow editors at Above the Law, Kathryn Rubino. How are you?
I'm doing pretty good. How about yourself?
You know, not bad. So we are here in the midst of a fairly busy week, and a week that I think a lot of us assumed was a full 5-day week just a month ago. But I've been informed that Donald Trump has invented Juneteenth, and so therefore...
Listen, I'm not in the business of ranking the ridiculous/offensive things that Donald Trump says. That would be a full-time job. But it is pretty both ridiculous and offensive, the notion that he invented Juneteenth, since, it predates his birth by many, many years.
So yes, as of a few months ago, or a few weeks ago even, the concept of June 19th being a holiday was one that was foreign to a lot of folks. It was even the subject of some popular culture efforts to make it a holiday, given its longstanding significance in the African-American community. And in the wake of what's been going on, perhaps not really reparations or anything, but in the wake of what's going on, it has emerged and bubbled up as something that corporate America, by and large, is viewing as a long overdue holiday. So tomorrow, people didn't think this was going to be a holiday, but tomorrow, for a lot of people, it is, isn't it, Kathryn?
It sure is. It's pretty good news. You mentioned that pop culture has kind of been pushing this for a little bit. There was an episode, I think it was just last year, of Blackish about Juneteenth. And one of the things that they say there, because, I've covered the effort of big law firms to take the day as a holiday. And it's not, getting Juneteenth as a holiday, recognizing it as a holiday is not the end of racial issues in this country. But as the show said, it feels like a good step. And it's in a lot of ways forcing white people to recognize not only that slavery happened, but that, it was something that a war was over, as opposed to just, something that's the faraway past or some distant memory.
So what's going on in the big law world vis-a-vis this?
Well, like much of corporate America, a lot of folks are getting the day off. We first, at Above the Law, became aware of it last week when Skadden sent in an email to everybody at the firm that, they would have the day off, that it would be, that should be a firm-wide holiday and they should treat it as such, which was, a pretty great thing. And since then, quite a few firms have joined on. I'm currently tracking 55 other big law or boutique law firms have told their firm that it is a holiday. I guess a couple have it as a half day. One has it as an optional holiday. But that's significant considering it was absolutely not a holiday last year at any of these places.
No. So we've been tracking kind of over the past few shows, some of the response of law firms to recent events. And it seems as though this is a new one. By the time this episode comes out, obviously the holiday will have passed. But
I expect
it is
that this is not a complete list by any stretch of the imagination. But it's a floor. At least 55 firms have done this.
And, getting 55 firms to agree on anything other than following Cravath's bonus schedule is really hard.
Yeah.
So it's a testament to what Skadden managed to get going here. And I mean, we can track that Skadden is the first actor.
I have not heard otherwise. And I've been saying that for a while now. But, it is, listen, big law is very much follow the leader in a lot of ways when it comes to compensation, when it comes to bonuses, when it comes to hours requirements in a lot of places. If it's already been done by other folks, firms feel very comfortable saying that they too will do this. And this is a great instance of that, where Skadden came and said, this is a holiday, and a good amount of firms have agreed.
Well, we'll see and be keeping our eyes on firms making this a permanent holiday as opposed to
a one-off,
thinking they can do this as a one-off.
Sure, that is very fair, and absolutely something we need to very much be mindful of. We're not going to solve racial tension in this country before 2021. It seems unlikely.
Fair enough. So what else has been going on this week? I hear that the Supreme Court was active.
Oh, yeah. I mean, I think that, and I struggle to really know whether a pair of new cases that the Supreme Court handed down are actually good news, or we are just so starved for good news in this country that that even small things seem like a really big deal. Although, of course, the Supreme Court holding that civil rights legislation did extend the concept of sex, did extend to sexual orientation, was something that was very, and LGBTQ folks, that was something that was obviously incredibly important.
And now, too, unfortunately, because this is the crux of that case, we need to be a little bit more precise.
Mm-hmm.
The 1964 Civil Rights Act does not protect sexual orientation. It protects discrimination on the basis of sex. It just happens to be that the Supreme Court, fairly utilizing their logic, which is pretty sound in this case, realized that sexual orientation is kind of wrapped up in the basic concept of discrimination based on sex. Sure. It's not like it expanded it. It just said that there's no way.
Included underneath that umbrella.
Yes. Yeah.
Sure.
There's no way that you can discriminate on sexual orientation without implicitly discriminating based on sex. And to that extent, it is covered.
And I mean, and it is something that is a pretty big deal. There are quite a few states where people could absolutely be fired if their employer wanted to fire them because they were gay. And the fact that they cannot do that anymore is absolutely something that should be applauded and celebrated. But I know that you also wrote that, liberals should be careful before they celebrate a little bit too much, because, the opinion was written by Neil Gorsuch, which doesn't sound exciting on the surface.
So it was a 6-3 opinion with Roberts and Gorsuch both on top of it. Gorsuch wrote it, and it is heavily influenced by doctrines of textualism. It is a love letter to the concept of textualism. He dumps a bunch of dictionary definitions in there and says,
as Webster's dictionary defines.
Yeah. No, he's that guy at a wedding.
Yeah.
Yeah, no. So he said that he limited his decision to, hey, this is just what I'm forced to do because this is what the text says. That is a little problematic, given that some of the arguments being made in the case reached towards broader issues, constitutional issues about equal protection and so on and so forth. None of that comes through. It becomes a straight statutory determination that the words have to be defined this way. But it is also, in the way it is written, a warning for anybody who is concerned about things like the Chevron doctrine, that this is still a very hostile court, and it's a court that's going to use lines from this opinion as marching orders for lower courts to do a lot more mischief. I think there's lines about how, reading anything beyond what Congress explicitly put down is particularly dangerous. I can see that line being quoted in the next district court saying that, some regulation against a toxic chemical in a river can't possibly be covered by the Clean Water Act because, the Congress didn't say it. These are the sorts of collateral attacks that are going to be born out of a decision like this. And so while everybody was celebrating the result, I was the Debbie Downer who pointed out to everybody that, a lot of what's being said here is going to be etched. A lot of the way it's said is going to be etched in your nightmares going forward.
Right.
As multiple progressive legislation is going to be run aground on the rocks of what Gorsuch writes here.
You were a bit of a Debbie Downer, I think, on that decision, but I also think that...
Thanks. No, that's great. Oh, you did say on that decision, I guess, but I was going to say, when you said that, I felt like, you were saying that I'm just generally a down person. I think I'm a super fun person.
I'm not attacking you as a human, nor do I think that Debbie Downers are necessarily a bad thing. I think that, Listen, I
Nice
watched
save.
that movie Inside Out, and sadness was the real hero there, right? Like,
Okay, fair enough.
so I'm not making that kind of a claim, but I also think it was really necessary. And I think that the left in particular is very desperate for good news. And this is good in a lot of ways, but making sure that we're still ever vigilant and wary of what it means. And there aren't a series of, articles and social media posts lionizing, the great in-between jurist, the great moderate Gorsuch is something that we should be aware of. But it wasn't the only time you were a Debbie Downer this week, or
That's true. I
so
followed
maybe
that up
it is
with-
you. Maybe it's not just the decisions.
Wow.
Maybe we've
Wow,
identified something. Would you like to talk about that? How do you feel when I call you a Debbie Downer?
I mean, I feel attacked is what I feel.
Do you? Do you really?
yeah.
Like, that's very interesting. No,
Not really. Not really.
not really.
This is the sort of blame I get for everything I say all the time.
Yes, well, life is hard as a straight white male. I mean,
it's so difficult. Yeah. No, but seriously though, I've heard, this is an aside, I've heard far too much of my fill of people explaining how hard their lives are as straight white people. Yeah. So moving on from that, this week also there was another decision that Roberts handed down about the DACA program, and there was obviously the administration attempted to end that program, which was a executive order run program that was just a deferral of deportation for children who came to the country in an undocumented way. So, and just basically saying, we know we technically can deport you, but we're going to all agree not to. And that's what that executive order said. And the Trump administration tried to get rid of it. There were multiple lawsuits all over the place. That was resolved today. That gives you a sense of when we're recording. That was resolved this week. And the court determined that the decision to get rid of DACA was arbitrary and capricious, those magical words for anybody who took administrative law.
Ding, ding, ding.
And to the extent that it was arbitrary and capricious to get rid of it without in any way in their explanation of why they got rid of it, considering reliance concerns and forbearance, therefore the suits against the government can move forward. Any attempts, kind of to post hoc determine why they did it in ways that are more, that are better. It's the old Seinfeld where he says he wants to return the jacket for spite, and they say, oh, well, that's not a reason. He says, oh, then it doesn't fit. And they're like, well, I'm sorry, you already said spite. That is exactly the determination that Chief Justice Roberts makes when he's arguing with Kavanaugh about it, saying that, like, look, our rule is pretty clear. It's what was their reasoning at the time? And their reasoning at the time was arbitrary and capricious. So.
Yeah, I mean, I know when the tweets started happening this morning, when the day the decision was released, my initial concern was that Sonia Sotomayor only agreed with part of the decision. And I do think, ultimately the distinctions that she was creating actually are pretty meaningful.
Yeah, as a technical matter, the decision was bifurcated, and it was a 5-4 on one issue, the issue that I just outlined, that arbitrary and capricious issue. And it was an 8-1 decision with Sonia Sotomayor as the only dissenting justice on the question of whether or not the plaintiffs had an equal protection claim that they could pursue. Obviously, these were dismissed at a preliminary stage, meaning that the line for what constitutes a viable claim was pretty low. And
Right.
She said that given how low it was, they seem to have pleaded that there were statements that suggest that this was done as a product of racial animus, and that should be something that the parties should be allowed to explore in discovery and further litigate.
That seems pretty reasonable to me.
Well, the argument of the other 8 justices was that, sure, you may be able to compile, as these plaintiffs did, comments that Donald Trump had made that were suggested that he was against immigration from Mexico and South America generally as a matter of policy that seemed to be racist. And you could also point to specific things he'd said about DACA that seemed racist. Obviously, he doesn't have these problems with all immigrants, just the immigrants from there. That all seemed like a problem. But the majority opinion says, but this decision was really technically made by the Attorney General and the Acting Secretary of Homeland Security. And you can't really say that things that Trump said were things that they were responding to, as if they don't work for him. And Sotomayor said that's probably not true, that there's no real logical reason why we should blinker ourselves from the context surrounding these policies and say, ignore all that. And
don't ignore the man behind the curtain. Kind of getting
that's
into
actually,
weeds.
Have you not read? I don't think
No.
you've read my piece yet.
I have not.
Yeah, well, that's the framing device for the whole piece. So thanks.
Oh, look at that.
Yeah. Wow. Good job.
Look at that. I mean, I guess it's bad that I haven't read your piece yet, but I've been busy. I've been working. But this might be a little in the weeds for folks who are only casual court watchers. But it strikes me, what can we take away? What can we draw from the fact that Sotomayor stands alone on this issue? Oftentimes people consider, Ruth Bader Ginsburg as sort of this like liberal lion, and there are very reliable liberal votes from the other justices as well. Why do you think there's this clear delineation on this vote?
That's a great question. I feel like Sotomayor is the only one who seems to really have a grasp of these kind of broader issues. I feel like the other justices are a little more concerned about cabining issues. They like the idea of making hyper-technical decisions and not taking a look at the broad circumstances around things and recognizing that a lot of direct lines get obscured in broader movements. They were content to say, well, if he said that we need to build the wall to keep people from shithole countries out, that was 2 years before he did this DACA thing. So I'm sure those aren't related. And she said, well, it's possible that maybe we should take the whole context into play.
Guys, you see what's going on over here.
And I feel like that really does speak to a more forward-looking, and like this is, I would say newer, but these were doctrines that were being discussed and theories that were being fleshed out in the 90s. But I mean, it speaks to kind of a critical legal approach to things, to not allow yourself to get tripped up by the technicalities of texts and stuff like that, and to recognize that law exists within a society, and all of the attenuating circumstances surrounding decisions are valid and important to understanding what's going on in the law. And she seems willing to do that, and the other justices aren't. Obviously, Breyer is well known for being a ticky-tack sort of a person. He was instrumental in the creation of sentencing guidelines, right? Like that's the kind of worldview he lives in. Yeah, Kagan is a professor and thinks that way. I think that I don't quite know what Ginsburg's issue is on these issues, but yeah, Sotomayor kind of stands on her own on this.
Yeah. Again, my initial reaction was like, uh-oh, why is Sotomayor by herself on part of the majority decision? And I think that you're right that, she's really the justice that is kind of looking at the whole picture, the bigger picture, the most consistently at least.
So anyway, that's another thing to be a little down about. The court, this was technically the last day for the court to release opinions. Obviously, this was not the end of the opinions that they have. So there will be more to come. But we're going into overtime. I mean, this was bound to happen. Yeah, I mean, this is overtime for the Supreme Court. It's one of those things which isn't OT because that's October term. So I guess we got to have a different form. Yeah.
Well,
injury.
okay.
This is injury time for the
nerd.
Supreme Court. This is injury time, and that makes sense because we had a lost month in there when we had to shut everything down. So
what other stuff? I know that another kind of angle you've been working this past week involves naming various law firms. This past week, we learned
You want to talk about that?
Yeah. We learned that Aunt Jemima syrup is no longer going to be Aunt Jemima syrup. Uncle Ben's, is getting a revamp in light of these kind of massive global brands taking a closer look at the reasons why they were named that and the heritage and sort of the history of these symbols. I think the same lens can very much be turned on big law.
Yeah, a lot of people don't really think about the people behind big law names a lot,
Sure.
Unless they're super famous. Before Dewey Ballantyne went under, I think everybody was aware that was the Dewey who lost, who defeated Truman, quote unquote. And I think people know that Wendell Willkie of Willkie Farr was a nominee against FDR, but with the exception of those really, really high-profile people in law firm names, they tend to become names, and you forget about them. But they are on the door because you're memorializing certain people, and it's worth remembering that. And to that end, Davis Polk, which is a pretty well-known big law firm.
Top 20 law firm, right? Am Law rankings.
As elite as global law firm brands are. Davis was a well-known segregationist lawyer who used his legal practice to, he was responsible for securing the constitutionality of the grandfather clause, a term that we use fairly loosely these days, but was actually designed to allow states to use literacy tests to prevent black people from voting, but they didn't want to prevent the white people who just were hillbillies from being able to vote. And so they created this grandfather clause that basically said, if your grandfather was able to vote, then you get to, which, as it turned out, meant that people who were alive, before black people were given the right to vote. So therefore, it only would ever apply to white people. So it allowed white people to avoid literacy tests. That's what grandfathering means. And that was a case that Davis argued. And it's not just that he was an advocate who took a case and, he can't be held. We shouldn't hold lawyers all the time to the positions they take in courts. That's
a lot of times, but yeah, okay. I see your argument.
But I do think that people should be able to have zealous representation from people who don't necessarily have to believe them.
Sure.
But there's something different when you're a prominent attorney. He served as Solicitor General for a while too. He was also a presidential candidate. He had the business ability to choose his clients, and what he was the go-to client of segregationists. He also was the lawyer on one of the companion cases to Brown v. Board, arguing that he was the South Carolina case, arguing that South Carolina should be able to segregate schools.
Right.
That's a case that there's some historical dispute about it, but that he may have taken pro bono because, that's public service somehow in his mind. But that's the Davis of Davis Polk. And, these are global brands, and they should, if Aunt Jemima can do it, I feel as though
for goodness sakes, we can certainly change his law firm's name.
I mean, yes, Holland and Knight is another firm. Spassard Holland was a U.S. senator who was one of the leaders of the filibuster against the 1964 Civil Rights Act. That's the history that you're dealing with these firms. And so...
Listen, these are firms who, most firms have come out now with very powerful statements supporting racial justice. Perhaps it's time to do more than talk and just blindly give money.
No, it's true. On the subject of blindly giving money.
Yes.
If, it's a thing that people sometimes do, and they shouldn't, because it can get costly. And if you're trying to cut costs, then you're not alone. In today's climate, a 5-figure e-discovery bill per month is steep. Don't pay that. Use Logical to reduce expense and control your discovery process. Get started today for only $250 per matter, and they'll waive migration costs from competing platforms. For more information, visit logical.com/LTN. That's logic with a K, CULL.com/LTN.
You really got me there. I thought you had. I thought this was a new subject of conversation that we were going to talk about.
Yeah, well, I will give people insight into the recording process. My computer crashed in the middle, and so I got off and forgot the ad read for quite some time, which is why I had to kind of force it in an awkward way there.
You got it done.
Yeah, we did. Well, anyway, yeah, so law firms, consider your names and how you feel about them and what they portray.
Yeah,
so
it's pretty important.
So, yeah. Well, anyway, so that was our week of discussing what's been going on.
Pretty busy week, I think.
Yeah,
especially considering it's only a 4-day week.
This was a busy week. We will obviously be back to talk to you about the week's news next week as well. Until then, you should be subscribed to this show. You can get it on all the various podcasting subscription places out there. You should be giving it reviews and stars. It helps more people find it when the services say, oh, this is a legal podcast. We know because people are giving it some reviews. So do that. You should be reading above the law. As always, follow us. I'm at Joseph Patrice. She's at Kathryn1, both on Twitter. You should be listening to the other shows we have. We have the COVID cast, ATL COVID cast, where we talk about COVID-related legal issues and how that's changing the landscape. We're going to talk to Jack Newton next week about it. We have the Jabot, Kathryn's show about diversity in law firms that you should be checking, and law schools too. I guess it's not just law firms in the legal world.
True. The legal profession.
You should listen to the other shows on the Legal Talk Network. I'll give a particular plug to Digital Edge's 150th episode spectacular coming up, which I'm on. So check that out. And with all that,
have a good week, y'all.
Said, talk to everyone later. Bye.
If you'd like more information about what you've heard today, please visit LegalTalkNetwork.com. You can also find us at AboveTheLaw.com, ATLRedline.com, iTunes, RSS, Twitter, and Facebook. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Legal Talk Network, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.